Federal and state regulators are scrutinizing and prosecuting healthcare providers and companies more than ever before. Therefore, investors in healthcare businesses need to conduct thorough health regulatory due diligence to evaluate the hidden risks involved in the investment. Additionally, because many healthcare providers and businesses hold licenses, health regulatory experience is necessary to ensure that a transaction does not inadvertently result in the termination of such licenses.
Health regulatory risks are not limited to any particular category of provider. In fact, you can run into them in a variety of provider types and a variety of companies that touch health regulatory issues but are not themselves providers. For instance, veterinarians, physical therapists, folks you might not typically think of as having health regulatory concerns do, both at a state and federal level. And then other companies that interact in the healthcare space, whether it be healthcare technology companies, revenue management companies, producers of drugs or devices. These entities themselves are not licensed, but because of their interaction with healthcare spaces and healthcare companies, they do face regulatory risks at both the state and federal level.
Healthcare regulatory risks are not just limited to doctors and hospitals. Healthcare regulations touch on all aspects of healthcare, not just the delivery of healthcare. For example, there have been innovations in the technology sector that relate to the personal health and wellness of consumers. These industries might not realize that healthcare regulations apply to their products too.
Health Regulatory Counsel's role in healthcare transactions should be to stratify the risks for an investor in a healthcare business. The key is understanding what is actually a red flag material compliance issue and whether and how that issue can be corrected. Many healthcare businesses are not fully compliant with all healthcare laws, but the job of experienced Health Regulatory Counsel is to identify the risks that can be corrected post-closing and identify the risks that must be addressed before the closing.
So for example, during the diligence process, we might uncover physician contracts with a healthcare company that aren't structured to comply with laws that govern those contracts. We identify the problems, and then we can advise the investor on how to restructure those contracts to achieve their business objectives in a compliant manner.
There are significant pitfalls for a prospective healthcare investor, several different levels. At the first is just ignorance with regard to reimbursement or regulatory trends that could render an investment not profitable or less profitable over the long run because of the changing health regulatory landscape. At the more immediate transactional level, it can mean improperly allocating or failing to identify important risks that can themselves render an investment less profitable or not profitable, or can raise significant costs later on when you try to grow the company in which you're investing. And if there are significant compliance risks, for instance, that are overlooked, the potential downsides to those can be significant, both in terms of monetary penalties to the company itself, limitations on the company's ability to grow, potentially limitations on the ability of the company to bill private or federal or state payers, and ultimately civil liability for the company itself, but also investors and potentially board members on an individual level.
Investors should understand the relationships between the target healthcare business and its referral sources and ensure that those relationships are compliant. Every healthcare business is looking for patients or customers, and some may be engaged in activities beyond what the law permits, whether knowingly or not. Healthcare businesses built on such relationships are very risky investments.